Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within 4th Commonwealth. Draw near, give your attendance, and you shall be heard. Now state the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on panel for the hearing in all of the cases we'll be hearing this morning. To my right and your left is Justice Peter Rubin. To my left and your right is Justice Gregory Massing. We are familiar with the arguments that you've made in your briefs with the factual and procedural history. In each case, you needn't go over all of that. We will have questions for you. Each side of the V has 15 minutes to argue. I don't recall that there are any cases on this morning's list that have more than one party on either side of the V, but if there is more than one attorney on either side, please let us know ahead of time how you'll be dividing your time. And just a reminder, there is no rebuttal. First case on our list for hearing is case number 2022 P205, the Commonwealth versus Manuel D. Alvarez.
Members of the panel, may it please the court, Elizabeth Lazar for the appellant Manuel Alvarez. This court should reverse the verdict in this case because the Commonwealth presented insufficient evidence of identity. Namely, it cannot be said beyond a reasonable doubt that Mr. Alvarez was the perpetrator. Among the possible inferences from the circumstantial evidence presented, the fact finder would have necessarily had to employ conjecture to reach that result. And under Commonwealth v. Croft, the Commonwealth cannot meet its burden even where viewing the evidence in the light most favorable to the Commonwealth, when choosing among the possible inferences from the evidence presented, a fact finder needs to employ conjecture. So here, the nurse's description of the perpetrator, the nurse, the victim, did not make an identification of the perpetrator, of Mr. Alvarez at trial. Instead, the nurse gave a very general description of the perpetrator, describing his physical attributes as having darker hair, darker skin, and scruff for a beard. Now, this is an extremely general description, and importantly, it's not in the record that Mr. Alvarez matched this description on the date of the incident. Second, the nurse described the perpetrator as intoxicated and flailing around. When the responding sergeant saw Mr. Alvarez in the treatment room, he was sedated to the point of being unable to converse, medicated. Now, there's no evidence in the record.
So your challenge, the sufficiency of evidence, centers, I take it, exclusively on identity?
Yes.
Okay. But we do have the officer's testimony that he was directed to the room where the defendant was being treated.
Yes.
Okay, and that was from the victim who said that my assailant is in that room.
Correct.
And there was only one person in that room.
Correct.
Viewed in the light most favorable to the Commonwealth, would a rational person sitting in a jury be entitled to infer that the one person sitting in the room where the nurse who was treating the patients in the emergency department and where he said his assailant was his assailant?
Not beyond a reasonable doubt, Chief Justice. Not beyond a reasonable doubt, Chief Justice. And this is why. The sergeant comes to the scene at around 9 p.m. It's unknown what time.
So in your brief, you talk about the timing.
Yes.
But the timing does not, it seems to me, the uncertainty or the lack of clarity concerning the timing does not derogate from the fact that the nurse who was responsible for those patients being treated in the emergency department pointed to that room is where my assailant is. So it wasn't a question of whether there was some time, some elongated period of time between the time when the person was put in there and the time when the officer arrived, because there was very little time between the time when the nurse said, my assailant is in that room, and the officer went into that room and discovered one person, the defendant, present there. Light most favorable, right? Light
most favorable. However, there are some factors that make that pointing out problematic. The fact that it was so far away, and this patient, the nurse was not the treating nurse of the assailant. It was not his personal patient, he testified. And the fact that this was an emergency room and patients are constantly being shuffled around. So that
evidence that the case, is there evidence that the patients are being constantly shuffled around, or
I think the fact that it was in an emergency room, and that's the nature of emergency rooms
So so like the general knowledge of the jury would be that patients scramble around?
yes, Your Honor. And so you'd have to assume that, excuse me.
The nurse was responsible to some degree for monitoring the condition and the location of patients in that area, right?
Upon arrival, he did treat the nurse, and he did testify that he was not his personal patient.
I understand, but, you know, whatever. The nurse said, that room, and the officer went to that room. Now, I understand that one could identify reasons or try to impeach the certainty or the accuracy of that statement, but based on the state of the evidence as it was put to the jury, you're suggesting it would be irrational to infer that that the nurse could have known that the patient that was in that room was the person who was his assailant.
Yes, and one other factor is important here, and that's the presentation of Mr. Alvarez at the time, where he was so sedated he was unable to converse, whereas the behavior of the assailant was quite different, and there's no evidence in the record that the perpetrator had been medicated to that degree. So he's presenting much differently than the assailant was described by the nurse, and there's no corroborating evidence as to his identity. Moreover, that testimony, and this is going to the next argument, should have been objected to on the basis of Herndon, and it should not have been allowed in, because the Commonwealth was required to talk to the nurse about his identification outside of court before asking.
To elicit from the nurse, not talk to them, but
excuse me, yes, Your Honor, I
elicit
apologize.
from the nurse on direct, and you're talking about Herndon.
Yes, I am.
So that raises in my mind just a curiosity. What's the end game here? Let's say we agree with you.
Okay.
That ineffective assistance of counsel in failing to object to the officer's testimony concerning identity requires a new trial. Do you harbor any doubt that at a new trial the Commonwealth will commit the same error of omission in failing to elicit that testimony on direct?
I think the appropriate remedy here would actually be reversing for that reason, because had counsel not been ineffective, a directed verdict would have been warranted. And so under Boothby, actually, it was just cited in the brief, counsel committed an error that, but for that error, a directed verdict would have been warranted.
Wait a second. Isn't our ordinary rule, assuming there's sufficient evidence here, in the sergeant's identification or transmittal of the third-party identification? And of course, we don't know what the Commonwealth has or what that victim will actually say about the defendant. But ordinarily, where evidence is sufficient but admitted improperly, there's a new trial. There's not a reversal, right?
Yes. Yes, but the argument here would be that there's insufficient evidence.
Say that again?
The argument here is that there's insufficient evidence.
I understand that, but
yeah.
Chief Justice Green asked you, if we were to conclude that the Herndon problem was the problem,
Yes.
not insufficient evidence, wouldn't there have to be a new trial? And then, is there any point to a new trial?
If the Herndon objection was made, the Commonwealth wouldn't have been able to.
But that ship sailed at trial, and now you're arguing ineffective assistance of counsel.
Yes.
And as we test ineffective assistance of counsel's second prong, we're now looking at substantial risk of a miscarriage of justice. I mean, I suppose there is a degree to which the defendant missed an opportunity to successfully execute a gotcha defense. But again, we, as Judge Rubin observes, we test the sufficiency evidence on the evidence that was admitted to trial, including evidence that could have been excluded but wasn't based on ineffective assistance. We do not, when counsel at trial fails to object to essential, evidence that was essential to the conviction. We do not excise that evidence from the record and then treat the evidence as insufficient. We remand for a new trial. That would be the circumstance here. And so it would go back, and the Commonwealth would ask the victim about identity, and what's the point. But that question lurks in the background. But let's go back to Herndon, because you saw in the Commonwealth's brief the distinction between the circumstances discussed by the Supreme Judicial Court in Herndon, Justice Botsford in her opinion, and the risk of jury confusion. And this was a bench trial. The judge said that had the objection been raised, he would have allowed the Commonwealth to recall the witness. Again, as we're testing for substantial risk of a miscarriage of justice here, it's hard to understand how justice was not served in these circumstances, assuming, again, that we're past the question of sufficiency of the evidence, that despite your challenges to what one could know about the identity between the person who was placed in that room originally and the person that the officer discovered.
Mm-hmm. Well, Herndon also states that, recalling the witness is limited and inappropriately places a strategic burden on the non-offering party. And so, yes, it was enacted to reduce the risk of jury confusion, but this is also another factor that is important, particularly where it would provide the defendant with specific notice of the prior identification, and that would allow the defendant to fully cross-examine.
Is there any concern or claim here that the defendant was somehow caught off guard, that the nurse had directed the officer to that room?
Yes, in the counsel's affidavit, she expressed surprise that the victim did not identify Mr. Alvarez in the courtroom.
No, that's not what I'm asking. A different question.
Oh, excuse me.
The counsel was aware that the victim could have pointed to that room. She was just surprised that the prosecution didn't bring that out on direct.
Well, we don't know what the victim will say when asked. They haven't put in an offer of proof, have they?
No,
The victim could say, I don't remember, it wouldn't matter.
Right. But it would still enable counsel a more full cross-examination at that time. Okay, so for those reasons,
I'm just like, we have the, I just found in the record appendix, there's this statement of facts in support of the application for the complaint. Does that say that, that the nurse told the police officer that, that was the guy? What I want to know is, was counsel surprised by the officer's testimony that that the victim had pointed out the defendant in the room?
yep, I do not believe that it was in there, Your Honor. I just want to confirm that. If I might. I don't believe that was in the victim's statement, how he identified the perpetrator.
There was a motion in limine, but that didn't have anything to do, that was about the officer himself identifying your client as opposed to saying that the victim identified your client, right?
Correct. There are no further questions. I thank you for your time and request that the verdict be reversed. Thank you.
Thank you.
Good morning. May it please the court, Kristen Jang for the Commonwealth.
So let's get right to Herndon.
Sure.
I understand your argument. Is there anything beyond the sort of context of the discussion in Herndon itself that provides support for your suggestion that in a bench trial the Herndon rule is not ironclad?
Can you repeat that? I'm
Sorry,
sorry.
I'm sitting too far back. Is there anything other than the context in of the discussion in the Herndon opinion itself to support your suggestion that in a bench trial the Herndon rule is not ironclad?
Well, I think it's a really case-by-case determination. And in a lot of these cases...
Well, that's what you say.
Right.
But it's always nice to have support for that.
Absolutely. Unfortunately, Herndon has not been interpreted a whole lot by this court, so there's not a whole lot of...
But doesn't it clearly announce a rule that you have to introduce the third party who did the identifying, that person's statement, before you can have the other person, in this case the sergeant, testify as to following her identification?
Yes, I agree. The rule is very clear, and I can see that it was
Okay,
not
and
followed
doesn't
here.
it does say something about jury confusion?
Yes.
But that's in a sentence that begins with some word like, in addition, or furthermore.
Well, I think it goes to the issue of prejudice to the defendant. So in a lot of these cases where the pretrial identification is being admitted substantively, you have a case where the witness recants or the witness doesn't remember making the identification. Maybe that's why the Commonwealth is trying to bring it
Okay,
in
and
this way.
is that this case?
That's absolutely, I don't
How
think
do you
that's this
know?
case. I suppose I don't.
You don't know?
I don't know.
Okay, so we have to have a new trial, it sounds like, doesn't it?
I don't think so, because I
I
think...
thought you said that if there was, a recantation or can't remember, then to protect the defendant, you would need to call the original witness first.
I said that it
And you've
goes-
also said you don't know in this case, so why
I
don't
don't
we?
know in this case, but the judge in this case, who was the finder of fact, said that if the objection was raised, he would have just recalled the victim. It was
Yes,
a
but
very-
that's not permissible, right? That's what Herndon is about. It says you can't put the defendant to that strategic choice. So, although they allowed it in that case, they said in the future, you have to call them first. That's the
agree.
rule, right?
I agree, but when you're looking at the question of prejudice, the reason that jury confusion was raised is because bringing another witness back just for a...
So you're saying they've announced a rule, but the rule has no prejudicial effect.
That's not what I'm saying. I think you have to look at it in a case-by-case
Okay, and
way.
why in this case is there no prejudicial effect?
Because this judge said he would have just recalled the
Yes,
victim.
but you
even
can
if the
always
victim said-
recall the witness.
I'm sorry, I didn't hear that.
You can always recall the witness. That's what Herndon says, but it says that's not good enough.
Well, the judge could have said no for one reason or another, and maybe the witness is not
Why
available
would it-
later.
Okay.
Let me ask the question a slightly different way, because it's always a challenge to try to rewind the tape in these circumstances. But let's try to do that as best we can. Let's go back and imagine that defense counsel did raise the objection. And upon that objection, the judge allowed the objection, suspended the testimony of the officer, and recalled the victim.
Yes.
Victim testified, provided the necessary predicate. The officer continued then and continued with his testimony. And the judge convicted the defendant, and the case is before us on appeal.
Yes.
And then the defendant argues that it was error under Herndon for the judge to have allowed the Commonwealth to recall the victim. What are we to do with that?
But I don't think it's error. I don't see how it's error if it's a bench trial. The judge is not going to be confused by this procedural error on behalf of the Commonwealth and recalling the victim.
So a judge sitting without a jury, despite the announcement of the rule in Herndon, has the authority to disregard the Herndon rule announced by the Supreme Judicial Court.
No, I don't. That's not what I'm saying. I'm saying in these particular circumstances
Not disregard the rule. I stated it too broadly. To disregard that portion of the Herndon rule that says that you may not recall the witness to overcome the problem.
I don't recall that it says you may not recall. I think it says it's not, in most cases, it's not good enough. It's prejudicial to the defendant in most cases, but I don't think it says it's not permitted. It's not permissible.
And why is it not prejudicial in this case?
Because in this case, I think the defendant even says in his brief that if the victim is recalled on this issue, it's very likely that the victim could have provided evidence that was
Very likely? How do they know? How do you know? How would the judge know?
I suppose we don't, but even in the worst case scenario, the victim says, no, I don't think that's the guy. There's still sufficient evidence of identity here. Because
Yes,
he
but you couldn't have introduced the Andrus testimony. You've conceded that without the victim saying something. If the victim said, I have no recollection of any of this, I don't know what you people are talking about. Didn't you point to a room? I don't think so. I don't remember.
Even if
Did
he
you
said
know
that-
what room the person was in? I got no idea. I don't remember. I don't think, do you think you could then introduce the third party? There's no foundation for it.
No, you still could.
You can.
You still could. But there'd be a question of whether the jury now or the judge believes it.
Right, you absolutely can. There's a case right in point that I cited in my brief, the conduct law cases and the progeny. You can still admit it substantively. This is the problem here. This is what Herndon is trying to deal with, is to give the defendant the opportunity before that third-party testimony comes in to really get at the circumstances of the idea. I don't think this is really a great case for it here. We're talking about a hospital where this person came in screaming, bit a nurse, and then is being treated at the hospital in a particular room. This is not an identification case.
But why isn't it ineffective of counsel to, even though maybe it wasn't, but counsel's asleep at the wheel, they're like all of a sudden this great opportunity has been presented to counsel. The nurse doesn't do the Herndon thing. The nurse doesn't identify the defendant. They fail to object. They shouldn't have let that come in. I mean, they conceded. Basically, defense counsel conceded ID.
Yes.
When if they were sharper, they might have actually got a not guilty.
I don't know. I wouldn't go that far. I think the circumstances of this case it's not, as the judge pointed out in the findings, this is not like a hit and run where the person sped away. And there is a real question of identity. The perpetrator in this case was being treated at this hospital, even if this nurse wasn't his.
Well, there wasn't a real question of identity in a global sense, but on the state of the evidence, there was no evidence concerning identity because no one really considered the question in controversy, but that doesn't relieve the Commonwealth of its burden to meet each element.
I agree, but I still believe there was sufficient evidence here because we have evidence from the officer that said the victim pointed out the room, and I found the defendant in that room.
But that wouldn't have come in on a proper objection.
Well, on proper objection, the judge said he would have just...
What Judge Massing's point in saying that they would have gotten a not guilty is that they would have excluded all evidence of identity had the counsel not been asleep at the switch.
But the judge in this case said he would not have said that evidence is inadmissible. He would have simply just recalled the victim, had that evidence come in, give the defendant the opportunity to cross on that issue and move forward. That's what the judge in this case said he would have done. Mm-hmm. I don't think it would have led to a not guilty.
But does the judge say that? And even if then the nurse had said, I don't remember doing that, I would have still believed the cop.
Yeah, the judge absolutely could have found that. I think
but does Judge Chapman say that? He said I would have let him recall the witness.
No, he doesn't. He doesn't go into the hypothetical of if the victim, said I don't remember. He doesn't get into that.
I mean, because recalling the witness might or might not cure it.
Say that.
It would. If we don't know what happened, if he did allow him to recall the witness, that might have, the witness might have undermined the officer.
Correct. We don't have that information, but at the same time, the judge, over and over in his findings, says, I didn't see an issue of identification in this case based on the fact that this happened in a hospital. And in the defense counsel's affidavit, she said, based on the way the judge was making decisions in this case, I just did not think identity was going to work.
And based on the fact that defense counsel conceded identity right from the get-go.
Well, defense counsel isn't obligated to launch every single defense possible under the sun. It's actually a sign of an effective counsel to focus on the best defense out there.
Mm-hmm. Right. It would have been hard. If it was my client, wasn't he acting in self-defense? Whoever the person was, yeah.
Right. And if there are no further questions, I'm happy to rest on my brief.
Seeing none, thank you both.
Thank you.
The next case on our hearing list is case number 2021-B-1056, the Commonwealth versus William J. HURCOMBE, Jr.
Chief Justice Green, members of the panel, may it please the court. My name is Tim St. Lawrence. I represent William HURCOMBE, Jr. The judge's failure to instruct the jury on an essential element of the offense of indecent assault and battery on a person over the age of 14 was fundamental error. It violated Mr. HURCOMBE's constitutional right to a jury trial, and it lowered the Commonwealth's burden of proof. The Commonwealth on appeal admits that it was error, but says that a new trial is nonetheless not required because the error did not create a substantial risk of a miscarriage of justice. Inherent in the error, though, is that justice may not have been done. This is because Mr. HURCOMBE stands convicted even though a properly instructed jury may not have found the omitted element of lack of consent proven beyond a reasonable doubt, and in that case would have acquitted Mr. HURCOMBE. And so Mr. HURCOMBE now stands convicted for conduct which may not have been criminal. This is the quintessential substantial risk of a miscarriage of justice because the evidence in this case, upon close scrutiny, was not so overwhelming that the jury were required to find lack of consent proven beyond a reasonable doubt. I say this because this case, the Commonwealth's case, rested largely on the jury believing the complaining witness's version of events.
Well, not entirely. There was other forensic evidence that corroborated the defendant's account of things broadly, but more specifically on the question of consent. It was clear, and just to put this into context, you know that the Commonwealth's argument is that not only was the evidence of lack of consent overwhelming, but consent was really not a live issue and the focus was not the defense theory, and for understandable reasons. The defense theory was that the thing didn't happen at all, and what really happened was a violent physical altercation between the parties.
I disagree that the omitted element of lack of consent was not related to an issue actively contested at trial.
I read the closing arguments. I didn't see the word consent present in either side's closing.
Right, but that's not, the standard is not whether the element itself was actively contested, but whether an issue related to that element was and the issue that was actively contested was credibility. That's from stem to stern.
But my question is, in what regard was lack of consent present in any identifiable way in the defense theory of the case?
The defense theory of the case was that Mr. HURCOMBE, let me back up a bit. The evidence showed that these, Mr. HURCOMBE and A.B.
They had a prior relationship, yeah.
Right, a prior sexual relationship. He had slept over her home about 10 days prior to this event.
But on this occasion, her tank top was ripped, her bra was torn open, she had bruises, he had an unfortunate encounter with a flower vase. Both of them were injured. There are a lot of things that could have happened.
Right.
Consent wasn't one of them.
I disagree with that because the evidence showed that Mr. HURCOMBE stated after they had hung out that evening for an hour and 40 minutes, never leaving one another's company, talking, hugging at the end of the encounter.
Yeah, he stated that she invited him, and he said that he had a text message from her doing so, but The text record, the phone records didn't support that, and the phone records also didn't support a completed call. So,
I disagree that the phone records didn't show a call.
they showed many, many, many calls.
Right, and
None of them answered.
They showed a call at 1:54 a.m. after she had left from him to her that lasted for, I believe it was 3 minutes, and it shows another call from him to her at 2 o'clock a.m. that lasted over 90 seconds. So I do believe there was communication after she left. He said that he was invited over, and he said that they began hooking up, that she was on top of him, and that's the last thing he remembers because he wakes up unconscious after being knocked unconscious with a serious head injury. So that puts, I think a jury can look at this case and say, even with some of the evidence that you referred to in the beginning, that this may have started off as a consensual encounter, and the touching may have occurred during the consensual encounter. She tells the first responding officer that the touching of the breast occurred before she was hit in the jaw, and a jury could have had a reasonable doubt about whether something that started consensually, something was said or done that changed the mood, and a struggle thereafter ensued. I think there's a motive. We don't know what happened to Mr. HURCOMBE. We know that he was hit with a vase and sustained a 4-inch laceration to the back of his head, bone deep, was rendered unconscious. He's now bleeding out.
Not bleeding out, but he
There's
lost a lot of blood.
There's a pool of blood
Right.
in the kitchen. A jury may look at that and say, well, now she may have a bit of a motive to fabricate some of the things that happened that evening. So I
This
think
is real.
that.
Well, go ahead, I'm sorry.
I'm sorry.
No, they had all of that. The jury had all of that
Right.
and weighed all of that.
But they weren't instructed on lack of consent. So if they believed that version, which is, I would suggest, a scenario consistent with the evidence, they still would have had to find him guilty under the judge's instructions, where lack of consent wasn't instructed upon.
This isn't really what your argument is about, but I wondered, you nowhere suggest that the victim is the one who hit your client over the head with a vase. Is that right?
That was certainly, I think that's an implication of the evidence.
Is it? Because I read that they were talking about maybe her ex-husband or something was hiding in the house.
I believe that was.
But she was never arrested for the assault?
No, she was not.
Okay.
That was a contentious issue at the trial about the third party potentially culprit. The Commonwealth's theory was that he did it to himself, which
That's
was,
impossible, right?
I'm sorry?
That's not possible.
I don't believe the evidence supports that he did it to himself based on the expert's testimony, the fact that he didn't have any markings on his hands, any injuries on his hands. He had a shattered vase and no injuries on his hands. It's just an implausible theory that someone would do that to themselves. But we don't, that issue was kind
Could have lost his, I mean,
Yeah,
it doesn't really matter, does it?
That's not really what this is about.
well, no,
It
it's,
doesn't matter. But the defense
it
sought
is a
to make it what
strange,
it's about in order to introduce a cloud of skepticism, at least, around what really took place.
right. I mean, it's a fact of the case that he was found that way, and
Right.
yes, but the issue that we're talking about today,
The principal argument that the defense advanced centered on those questions.
credibility was the defense. Fabrication, right.
I understand. And
As
they
a-
used the condition of the defendant upon discovery as the centerpiece of that argument.
Right, that at some point in time, after,
They didn't even go, they didn't express it with even the same clarity of articulation that you do now. But I guess, you know, there was no suggestion or even portrait in the theory of the defense advanced before the jury that the parties initiated consensual contact and then a violent confrontation ensued after that. There was nowhere in the argument presented to the jury.
I think that it was. I think that it was.
I'm all ears. Where is that in the closing?
The theory was that he was invited over. So in that sense, if he's invited over at 2 o'clock in the morning after being together and drinking for 2 hours, had slept together 10 days prior, were in a long-term sexual relationship, that he was invited over for a consensual encounter. And
Right. So
that
the argument was that his statement that he was invited over should be believed, and her statement that he wasn't invited over should not be believed. And what we have is the two of them discovered each in a state of injury requiring medical attention. Nowhere in the argument is there the suggestion that they engaged in consensual activity after he arrived in response to the invitation that then devolved into a physical altercation between the two of them. Nowhere.
well, we have a statement from him that she was on.
It's not in the, I mean, again, you have a statement from him that she invited him over.
And that she was on top of him, and that the next thing he knows, he's waking up in a pool of blood. So,
On top of
that
him,
goes
on top
to
of
the-
him
but
for
that
sex,
doesn't-
or on top of him to beat him up, to assault him. Wasn't the on top of him statement more like an assault, like a suggestion?
No, I think a
assaulting
jury
him?
would have reasonably inferred that that meant that he was invited over, they were engaged in hooking up, and that's the last thing he knows.
That's
Now,
an interesting gloss on that particular snippet of testimony, but it was not argued to the jury.
the question, the jury has to find every essential element proven beyond a reasonable doubt. Whether the
I know that, but
Commonwealth
I'm just
concedes
trying to
that
get you
element.
to identify for me where in the case was the theory that you are now presenting on appeal was framed for the jury's consideration, raising a live issue of consent.
That fabrication encompasses lack of consent, that she is not to be believed, that her version of events is not to be believed, encompasses that any touching that occurred not only perhaps didn't happen, but also did not, if it did happen, it did not happen without consent.
You know, I'm not going to ask you to point it out in the closing argument because you have 2 minutes left and you're not going to be able to find it. But I didn't see that laid out in your brief. The Commonwealth, in contrast, identifies specific sections of the brief that advance a different theory that doesn't involve anything to do with consent.
I thought the test was whether the evidence required the jury ineluctably to
That's where I'm going.
find the element, not whether it was argued in closing.
The risk we run, I would suggest to the court, if we don't
An issue in context.
adhere to a strict application of Azar, which was reaffirmed in Savello, is that now the court sits as a second jury without the benefit of hearing the live testimony, without the benefit of evaluating the witnesses, and without the benefit of deliberating the way in which a jury of his peers would have deliberated this case. And you run the risk of usurping the jury's fact-finding function unless you can say that it's inescapable, that the jury would have found the element of lack of consent proven beyond a reasonable doubt. I don't think that strict standard is met in this case. I submit that it is not met in this case, that there is a scenario consistent with the evidence in which could have raised a reasonable doubt in a single juror's mind. And therefore, to avoid the substantial risk of a miscarriage of justice that is inherent in this type of error, there needs to be a new trial in this case. I thank you for your time.
Thank you.
Good morning, Your Honors. If it may please the Court, Assistant District Attorney Timothy Ferreter on behalf of the Commonwealth. The defense in this case was clear, and the defense was that the defendant did not assault the victim, not that it was a consensual encounter between the defendant and the victim.
Why don't you begin by addressing Judge Rubin's question about the standard for review of the evidence. And I will confess, I haven't actually looked it up in the dictionary, but I think I understand in a general sense what ineluctably is supposed to mean.
Yeah, I think it means it's unavoidably inferred from the evidence, and I think that was clear in this case. So when reviewing, this court's review focuses on the omitted element. And I think you can look at a case like Gilbert for this, where in that case it was hotly contested the cause of death. And the omitted element in that case was malice. And there were experts on both sides talking about the cause of death. But once the jury found that the defendant caused the victim's deaths, malice could be ineluctably inferred from that case. And I think we're in the same situation here. It was hotly contested whether the assault actually occurred. But once the jury found that the defendant touched the victim and did so indecently, the omitted element of consent was overwhelming in this case. The victim testified extensively about the struggle that happened. Struggle is the classic evidence of lack of consent, and then that's corroborated by the bruising all over her body, her shirt being torn, her bra being ripped, and also in this case, the defendant laying bleeding on the floor. It would be really hard to imagine how consent became an issue in this case.
Hard to imagine how consent about the digital rape would be an issue either, I suppose.
Oh, well, we don't know how the jury found the
No,
defendant.
we don't, but your ineluctable argument really stumbles when you get to the aspect of the case. It's, and I understand she didn't ask for a rape kit, although it's not completely clear to me what a rape kit would show for digital rape, but all right. They were told about a whole sort of a series of events happening contiguously with each other. With respect to one of those events, the instruction properly included the consent element. With respect to the others, it did not. He was acquitted of this one. We don't know why. How can we say ineluctably they would have found a lack of consent here? If they would have, maybe they should have here too, but they didn't apparently, or maybe they didn't, we don't know. Ineluctably, I mean, look, if he'd been convicted of the rape and we knew that they had found a lack of consent for the more serious allegation for which she didn't get a rape kit, then it'd be a lot easier to say, look, obviously they would have found it if they'd been instructed on it in the indecent A and B, but they weren't instructed on an essential element of the offense. I don't understand. I mean, we see cases like this. I don't know how they happen, right? I mean, I don't know if it's the judge, the prosecutor, the defendant. The elements of the offense are not the trickiest part of the jury instruction. You'd think they'd all be in there, but not.
This is a very good and experienced judge, particularly in criminal matters.
Look, there's a lot to your question. I agree with a lot of it. I don't know why it was done incorrectly, and I think it would have been easier if they convicted on rape. I agree with a lot of that. I disagree because also with the rape, consent was also not the defense to that issue. And there were other issues in the rape defense
What
in
was the
terms
defense
of
for the rape?
credibility about it happening or not happening. I think the defense pointed out she didn't take the rape kit, that there was a lot of inconsistent statements about how the penetration occurred or whether it occurred, whether she was wearing underwear or not. There was a lot of cross-examination and argument about her credibility about whether the penetration occurred. But there was no argument.
The clothing she was wearing.
I'm sorry?
A lot of time spent on the clothing she was wearing.
Correct. And so there wasn't no argument on the rape either about her her consenting to that. So I it's hard to imagine the jury deciding on that element. We, of course, don't know. We do know the jury found that he was guilty of assault and battery on a household or family member when that was correctly instructed. And I think that's in some ways more telling than the not guilty on the rape, because in that instance, we know the jury found all the elements beyond a reasonable doubt, where we don't know which element the jury found on the rape charge. And also point out that the defense, my brother relies a lot on Portanova in his brief. In that case, the prosecutor, the defense, and the judge all stated that the most crucial issue in that case was consent. The judge described it as the core of the case. And here, as Chief Justice Green has already pointed out, consent was actually never mentioned by the defendant in closing. That's how far from the core of the case it was here. I think Silvello, it has a standard, and I think this case has, on the omitted element, has much more evidence than Silvello did. Silvello was, the SJC found that there was overwhelming evidence because the revolver in a loaded firearm case, because it was a revolver, some of the ammunition would have been visible. Here, we have much more evidence about lack of consent. The struggle, the bruising, the ripped shirt, the rip bra, the evidence of lack of consent.
Gap in that, of course, is the temporal sequence, as your brother has pointed out.
You mean in terms of them being at the bar before?
We don't know when in the overall encounter the physical altercation took place, and if the defendant is to be believed that he was there at her invitation, it is plausible to imagine that they began engaging in a consensual encounter, and then it turned into violence.
Again, but under the substantial risk standard, we look at the case as it was tried,
Right.
not how it theoretically could have been tried. And I think, in the abstract, when you know that a defendant and a victim have had a past relationship and the charge is a sexual assault charge, consent is something that's going to come to a defense attorney's mind. But then when you turn to the actual facts of this case and the injuries, the evidence, it obviously wasn't the defense because it just couldn't have been mounted in this case, and that's because of the overwhelming evidence of lack of consent.
I mean, this just seems a lot like Commonwealth v. Mitchell to me. In Commonwealth v. Mitchell, we wrote, "We are not permitted to weigh controverted evidence in determining whether failure to instruct on an element of the offense created a substantial risk of a miscarriage of justice. And in point of fact, even were it a relevant consideration, given the acquittals on the assault charges in that case, it's hard to say what it is likely that the jury would have concluded had they been properly instructed."
And I think the key there is controverted evidence. There is no evidence of consent at
Well,
the
the
time.
dissent said the key was controverted evidence.
I'm not
And
asking you to weigh controverted evidence.
most interesting thing about it is that it's a dissent.
I'm not asking you to weigh controverted evidence because there is no evidence of consent in this case at the time of the assault. There is some evidence that could have bolstered a possible consent defense in terms of their past relationship, but there's no evidence that she consented when the assault was occurring. All the evidence is that she did not consent. And so if there's no further questions, I'd rest on my brief.
Seeing none, thank you both.
Thank you.
Brings us to the next case on our list for hearing, case number 2021 P1134, the Commonwealth versus EDG Santos y Santos. Before you begin your argument, I just want to place on the record our awareness that the Commonwealth late yesterday filed a concession acknowledging ineffective assistance of counsel, warranting a remand of this matter to, in light of that concession, is what do we need to do today?
Good morning, Chief Justice Green and the rest of the panel. Keith Kaminsky on behalf of Eddie Santos. We still need to address
Can you move the mic up a little
Sorry about
higher, actually, I think, and maybe speak up a little bit? I'm sorry.
So I contacted the Commonwealth after receiving their filing last night. The only thing we're arguing about today is the disposition for this case. We both agree it should be remanded. However, the Commonwealth's position is that Judge Sorrenti should resentence Mr. Santos. My position is that due process requires a different judge to resentence Mr. Santos. and-
Wait, resentencing?
Yes.
I thought their concession was that there should have been an objection by counsel because there was no evidence of a notice requiring the defendant to reapply for the license.
Yes.
Oh, well, if there's no evidence of that, then he can't be found to have been in violation of his probation. Or am I misunderstanding that?
My position is that there are only errors at the sentencing phase of this hearing, so the only solution is resentencing. If the Commonwealth is in agreement that he should never have been found in violation of probation, then it should just be reversed.
Your position is not that he should never have been found in violation of probation.
Based on the case law I've reviewed, there's no support for that.
How can he have been in violation of probation without evidence that the probation condition was don't commit a new offense? Right? That's the condition he supposedly broke, and it even says in the notice what the offense is, driving with a suspended license or whatever, and then there's this statute. In no case shall a person be prosecuted for operating after suspension or revocation upon a failure to pay an administrative fee without a prior written notice from the registrar mandating payment thereof. I mean, I'll have to ask your colleague, but you think that nonetheless he was properly found to have violated his probation?
I think he received ineffective assistance of counsel, and he should never have been prosecuted for this July offense.
And should never have been prosecuted?
However, he pled guilty to the July offense.
Yeah, a long time later, maybe when he was already in jail.
Correct.
Well, what does that tell us? I'll plead guilty to something. I know the record doesn't show whether it's going to be concurrent, but my guess is it is. He's already in jail and he can get rid of this charge. You think that means he's guilty of it? I mean, I wasn't his lawyer there. Maybe you were. I don't know. Did they have evidence at that trial of him having been notified of when he pled guilty? But when the facts were recited in the guilty plea, did they mention him receiving a notice that he had to pay to reinstate?
No, they did not mention that. My understanding of this case is that Mr. Santos hired private counsel on the underlying OUI and wanted to file a motion to suppress. That judge told that private counsel that they were going to have a trial that day, so he pled to the underlying OUI offense, and then he was on probation. And once he was on probation, he was charged with operating after without a license because he drove his car 76 days after, and he was told only 45 days. And he never received notice. There was no evidence of that, and he never should have been prosecuted for it in the first place. So I would agree with the court, it should just be reversed.
Why would sentencing come out any different based on their concession? If you're saying their concession doesn't mean he's not guilty, how does the concession about the adequacy of the evidence alter the sentencing calculus?
It alters the sentencing calculus because he had a statutory defense here, and also, number one, he had the statutory defense that he didn't receive notice for this violation, the July offense.
Okay, but you're saying...
Go to revocation, not to the sentencing, not to the disposition.
The difference in sentencing is greater because in this case, the judge decided that he was going to go and gather 2 exhibits against Mr. Santos to impeach his testimony and then sentenced him on that. And that was an a judicial inquisition, essentially.
Look, there may be a lot wrong with the sentencing, but I'm trying to figure out the relationship between this concession by the Commonwealth and the sentencing. I mean, I don't understand anything about what the judge did here. I find it all a little mysterious. For example, maybe you can explain this to me. He says that the defendant lied to him about knowing in July that his license was still suspended. And this judge's alleged proof of that was that he was stopped for having a suspended license 11 days after he pled guilty. Well, that was within the 45 days. He certainly should have known then that his license was suspended. But the July one, unless something happened in May that extended the suspension or gave him notice that it didn't automatically at the end of 45 days end, I don't even understand the conclusion that he was lying. Do you?
That's correct. I agree with you completely. Mr. Santos understood his license was suspended for 45 days. And no
Well,
one
look,
told him
of
to
course,
go
we
back.
don't have to believe him necessarily, but I don't understand why the May stopping has any bearing on what he knew about what would happen after the 45 days. Do you? I'll ask your colleague as well.
It doesn't, and also if you look at the report for the May offense, they didn't take his license. He still had his license, even after being stopped in May. So he still had his license when he was stopped in July, his physical license.
And I take it that the May violation wasn't brought forward as a basis for revocation because of some administrative delay in bringing forward that complaint?
A complaint hadn't even been issued, and it wasn't issued until after this hearing on his probation violation. And that's why the
Disturbing portrait of a lot of things.
Yeah.
I would just add, at this hearing, you know, the Commonwealth, the probation department, and defense counsel, none of them had this May offense police report or knew about it. The only one who seemed to know about it was Judge Sorrenti.
Can I just say, so in terms of sentencing, resentencing, we're past the 6-month serve balance suspended for a year, right? This is all in the past at this point.
Correct.
And I take it the guilty plea to the July 7th, 27th was concurrent time or something, so there was no additional time because of that.
However, Mr. Santos is still on probation and still cannot drive a car until March.
What is he on probation for?
The underlying OUI offense, the sentence, he's still serving his sentence on probation.
This probation continues. Okay. Thank you.
The bigger picture I'd like to address is simply that Mr. Santos had a right to testify in his own defense before a neutral and detached hearing body. Instead of being able to exercise those rights, he, was subject to a judicial inquisition where the judge didn't believe him, so he went and gathered 2 exhibits against him. I think there's one quote that's pretty important on that, and that's where the judge said, "I'm not sure, it's really up to me to do all this investigation, but when I heard something that I don't truly believe, I'm a dog with a bone." That is not a neutral and detached hearing body, and for that reason, Eddie Santos should be resentenced before a different judge to restore the appearance of justice. Seeing no further questions, I would rest on the brief.
Thank you. Commonwealth?
Good morning, Your Honors. Stacey Gauthier, Assistant District Attorney for the Commonwealth.
Start with the question you know is coming.
Yes.
If the basis for counsel's ineffectiveness was that there was a defense for the basis of revocation, why is the remand for resentencing?
My understanding, and this is a very odd case, to say the least, but my understanding is that it would be remanded for a new hearing.
That's what I would think as well.
And I did speak to my brother yesterday, and I apologize if I wasn't clear and he didn't understand. But my position, or what I believe would happen was that it would be remanded for a new hearing.
But if there was insufficient evidence to prove the case because there was no evidence of notice of need to pay, what would the point of a new hearing be? Wouldn't it be with instructions to dismiss the violation notice? Because it only had one ground for revocation.
Right, and excuse me, the statutory defense was not raised at the probation revocation hearing.
But if it had been raised, wouldn't dismissal have been the proper outcome?
If there was a defense to it, that's correct. However, the defense, because it was never raised before the judge, it was never really fleshed out.
Yeah, but there's nothing in I read the transcript, there's nothing in there about notice to pay.
So if there was no notice to pay, if it had been fleshed out, and if there wasn't.
But isn't evidence, affirmative evidence on the lack of notice a required element of the Commonwealth's proof?
That would be a defense, yes.
No, is it an element? Is it an
No,
element?
but I mean, we now have the record of what was presented.
That's
The
correct.
question is a pure question of law, right?
Yes.
And so it's not a question, you were here for the argument in an earlier case where we talked about evidence that was allowed in without objection, and we test the sufficiency of the evidence as it comes in, even if there was evidence that could have been excluded, and then review whether counsel was ineffective for not raising that objection. This is different, because we have evidence that is a full record, and the ineffective assistance is the failure to advance an argument that is a pure question of law, that is now visible and present before us, and on the basis of that legal principle, we can conclude that the Commonwealth's evidence at the revocation hearing was legally insufficient to establish the grounds for revocation, right? And that's your concession.
Yes.
And on that basis, I suppose remand is necessary to adjust the state of the trial court docket, but as Justice Rubin observes, really nothing more than that. There's nothing more to hear because the evidence was what it was and it was insufficient.
So if you find that the evidence was insufficient, then.
There was no proof. That's the basis of counsel's ineffectiveness, which you have conceded, and frankly with which I agree, was that counsel failed to raise a conclusive defense based on the statute that the Commonwealth's proof was insufficient. And here we are.
If you find that the Commonwealth's proof was insufficient, then.
Aren't you conceding that it was? They did not?
We were conceding that the attorney was ineffective for not raising a statutory defense.
And that the failure to do so deprived the defendant of an otherwise available substantial ground of defense, namely that the Commonwealth's proof was insufficient.
Yes.
In failing to present affirmative evidence of the lack of notice.
Yes.
The notice, right. I don't mean to put words in
So I
your mouth.
apologize to the court then if I misunderstood.
I'm told that I can be, in my questioning, sometimes more assertive than interrogative. And I don't mean to put words in your mouth. But I'm just stating what my understanding is of the concession that you've made, and the concession that you have made is that if counsel at the revocation hearing had raised the statutory defense, it would have required a conclusion on the state of the evidence that the evidence was insufficient to support revocation because the Commonwealth's proof did not include a required element. Is that correct?
Yes.
Okay. So in that case, a remand would be warranted for the purpose of vacating the finding of a violation warranting revocation, and that's that.
Yes.
Okay.
If we were to remand for a hearing, I'm just trying to think if there's anything left of the rest of what looks to me like it may have gone wrong below. Would you agree that it had to go to a different judge?
No, I would suggest that there was no, evidence that Justice Sorrenti had prejudged the case. And I'm looking at Commonwealth versus Coleman, the case that the defendant cited to say that it should go to another judge. There was no evidence that he had prejudged the matter. As a matter of fact, he stated.
And can I ask you, I don't think it's really about prejudging, but can I ask you to explain, because I feel like I must have missed something or maybe not. How does his repeated insistence that because the defendant was pulled over in May, he necessarily knew in July that his license remained suspended even though 45 days had passed from the imposition of the 45-day suspension? He keeps saying he lied to my face, and then when he sentences him, he says, I believe in error. I'm sentencing him because he lied to my face, which is not why you're supposed to sentence someone. You're supposed to sentence them for the underlying crime. But do you understand this lied to my face thing, how it logically follows? I can't understand that.
Well, he indicated on the probation form where he revoked the defendant's probation, he didn't indicate on that form that he was revoking his probation based on perjury. It was because...
No, but I read the sentence appears to be based on his having lied. But do you understand what he means by perjury? How does the stop in...
I don't know that he necessarily means perjury.
He said perjury. He used the word perjury, so I'm going to stick with that.
Okay.
So what's he talking about?
His disbelief in the defendant, that his innocent explanation...
And do you understand how what he discovered about the May stop leads logically to the conclusion in July he had to know his license was still suspended? Do you understand that?
Well, just that the officer at the time that he was stopped in May had told him that his license was still suspended.
It was 11 days after the 45-day suspension was imposed. Of course his license was still suspended. My question is, how does that mean that 76 days after the suspension he still knew?
Well, even if you find that the judge based his sentence on the wrong reasons, it would still, it doesn't show that he can't be fair in another hearing, particularly if you...
Well, I don't know. He goes, he digs up stuff on his own. We have an adversary system. It seems a little inquisitorial, right? It's not great, I gotta tell you. I was pretty surprised by this.
Yeah, it's like, to say the least, it was odd.
Yeah. All right.
Our concern was that justice was done, so
So you're never going to concede again after this, I'm sure. It's the thanks you get.
At 4:30 the night before the argument, anyway.
Right. No, but so we do appreciate the concession. I want you to. But so if there's no basis, if the counsel was ineffective for failing to bring up a defense to this, then counsel who let him plead guilty on July 7th was also ineffective, right? I mean, if you move to withdraw that, you'd pretty much, on the basis of this concession, you'd pretty much have to. Unless the evidence shows that there had been the notice?
Correct. We don't have that plea before us. That's not being appealed, so we don't know what the factual basis of that was.
We're not, for some of the same reasons Judge Rubin just identified, we're not going to reach out and decide a case that hasn't been brought. But we are aware of the possibility that a motion to withdraw a plea under Rule 30 is certainly implicated by what you've now discovered, and we would entrust you to be consistent in your approach.
Thank you, Your Honor. I apologize, for all the last-minute confusion. we try to moot all of our cases, and we try to do it a couple of days in advance of the argument in case something like this happens, although unfortunately, sometimes with people's workloads and schedules, it doesn't happen until, unfortunately, the day before.
We all try to do the best we can, and we all encountered difficulties, and the most important thing is we try to get it right. Thank you for your candor.
Thank you, Your Honors.
Yes, thank you.
Thank you.
Both.
All right. Do you need a break? Okay. We will often take a break at the dividing line between the civil and criminal portions of our session, but I think we have only two civil cases remaining on the list, and we'll proceed with case number 2022 P-159, Paul J. Conway and another versus Thomas Caragliano and others.
Chief Justice Green, members of the panel, good morning. May it please the court, Joshua Siegel on behalf of Paul J. Conway and Gail M. Conway as trustees of the Riftwood Irrevocable Trust. First and foremost, this court should reverse the entry of summary judgment by the land court and should rule that the derelict fee statute, General Laws Chapter 183, Section 58, applies to the 1976 deed from Earl Boardman to Evangeline T. Anthony, which is the predecessor deed to my clients, the Conways' property.
You all have certainly brought an interesting case before us today. Let me ask you this. Were any deeds out of Boardman issued between 1961 and 1971 for inland properties?
I did not review the record with that question in mind. I don't recall there being any, but I can't say for certain, Your Honor.
When the registration was changed by 1151813, so that the 7th Shoreway appeared now on a map in that case, would you agree that all the landowners who had deeded rights to however you want to put it, or how did they put it, in and over the ways in the development now had right-of-way in and over the 7th Shoreway?
So that issue was not litigated below, and it's one that I haven't done.
Well, I think it actually makes sort of a big difference, doesn't it?
What I would say, Your Honor, is that deeds that were granted between the drawing of that plan in 1961 and the deeding out of this lot in 1976, all of those owners certainly would have had rights in the 7th Shoreway.
Okay.
Rubin's question.
Yeah, that is.
So whether as the...
But you don't know of any deeds in the 1960s from Boardman? You think he stopped giving deeds out before 1961 and never gave another one till 76?
Yes, Your Honor. As our title research found, which is reflected in the complaint that was originally filed in this action, the development was completed and all the deeds for the previous sections through the 6th Shoreway area were completed by 1961. We allege that in the complaint. And then this extra land was drawn up and additional properties were deeded out.
Why did he create another Shoreway in 1961 if he wasn't planning on selling any of the remaining inland properties?
I don't know if there were remaining inland properties.
Well, we know there was one because your opponent owns it. What year was that sold to Anthony?
Anthony purchased it in 1976.
Okay, so nothing in 1961. He goes to all the trouble of registering this plan, just on the off chance he later is going to sell someone like Anthony an inland parcel.
Well, Anthony had the oceanfront parcel. It was the Caragliano.
Oh, I'm sorry, the Hazards.
The Hazards, yes.
They take from Boardman?
They take from Boardman and they take after Anthony.
Did that parcel have easement rights over the ways in the 11-518 case before it was sold to Hazard?
There was no deed from Boardman to anyone concerning that property, and so there's no deed that grants the owners of that property.
But you think he owned a fee interest in that 7th Shoreway? He didn't need an easement. As long as he owned it, he could just keep walking over the 7th Shoreway.
Yes, Your Honor.
Huh, okay.
And so, turning to the plain language of the derelict fee statute.
Well, before we get to the derelict fee statute, because the derelict fee statute concerns the fee.
Yes, Your Honor.
And the question that I always find myself puzzling in these cases is whether easement rights arose without express grant, either before or upon the severance from common ownership by implication. I mean, the derelict fee statute, it seems to me, also applies to the frontage of Lot 211 on the cul-de-sac, Westwood Road. And yet there's no contention anywhere that the Caraglianos have no right of access over Westwood Road for access to Lot 213.
Your Honor, it would only have gone to halfway down Westwood Road, and
It's only going halfway down the 7th Shoreway.
No, Your Honor, because Mr. Boardman had already sold the land on the other side of the 7th Shoreway when the 7th Shoreway was drawn. Therefore, if the derelict fee statute applies, it would operate to grant the entirety of the 7th Shoreway.
Wait. When did he sell the one across the 7th?
It was before 1961, is my recollection of the record, Your Honor.
All right, so the derelict fee statute has nothing to do with that half of the road.
No, under the derelict fee statute, if a landowner owns a way and property abutting it and not the property on the other side, when the landowner grants the property abutting the way, the landowner also grants the entirety of the way. If he owns the property on the other side, it only goes to the halfway line.
But so, I mean, suppose we agree with you that the derelict fee statute applies, and your client owns the fee underneath the right-of-way. How does that extinguish the right-of-way? I mean, I'm reading, I've pulled out this book. The derelict fee statute pertains only to the question of ownership of the fee, in a way. It is not concerned with the existence or nature of any easement rights there. Why, and when your deed says, maybe it said that you've got an appurtenant, that the right-of-way is appurtenant. Actually, maybe the better language would have been subject to, but it's clearly disclosed on the deed that there's a right-of-way there.
Your Honor, two answers. The first is that if Mr. Boardman granted the fee interest in the 7th Shoreway to Ms. Anthony on the date was, I think, May 6th, 1976, he no longer, and didn't reserve any right to grant further easements in that property. And did not ever grant himself an easement in that property, in that right-of-way. Then he could not, by virtue of a deed on May 17th, a week and a half later, grant an easement in that property to the Hazards.
That's why I asked whether every other inland owner, as of 1961, had an easement over your way. I mean, I know it's the Caraglianos you don't like, but there may be 25 other people who want to go to the ocean through the 7th Shoreway sometimes, and you wouldn't be able to exclude them. You agree that if he had given easements to somebody else already, he doesn't have anything, he can't, by giving you the fee, extinguish them. They bought them for, consideration at some point.
And so, Your Honor, first, I have no personal animosity toward the Caraglianos.
No, I understand you don't, but I feel your clients may.
And the response is that in this case, the plaintiffs bringing this action are the ones claiming to have rights in the Shoreway. If somebody else brought the action now, there would be additional defenses.
Wait, I thought you were the plaintiff.
Sorry, excuse me, the counter plaintiff.
Yeah, so you just sued, you didn't sue everyone to get you won't quiet the title to this by this action.
No, Your Honor.
As against them, you will, but there could be 40 other people who may want to get some money from you instead of giving up their rights to the easement.
This action originated when the
I
Caraglianos
would
were...
think the Caraglianos, unless everybody in the area feels the same way you do, could go around to them and say, you know, they blocked your easement. You might want to give them a call.
And if they do that, I think, you know, we would have additional defenses in a new action, such as latches and other things that
Let me go back, if I may, to my previous question and Judge Massing's follow to that question. Again, it's puzzling because the derelict fee statute comes into place only if it concerns land that is away. And inherent in it being away is that there are easement rights to pass over it. If it's not, then what makes it away?
something can be away by being designated as such before anyone has gotten an easement
I understand
over it,
that.
which is our
But
contention here.
the point is that, that quite often the circumstances in the establishment, and I understand we got the Patel case in North Andover that says that just putting it on a plan doesn't grant easement rights. But one question, the circumstances of this case at least, there is a serious question of the intent of the grantor, right, in severing lots out of common ownership. At the time when he sold Lot 211, he still owned 213. I realize that they were relatively contemporaneous, but under the way that the Registration Act applies, 211 was severed first.
Even though it was severed second.
Even though the deed was executed second.
Yeah.
No, but it was transferred. It was transferred first.
I mean, I get it, but there must be some equitable rule here, but go ahead.
Quite apart from that, it's hard for me to imagine a construct in which the grantor, I'm looking at the plan, intends to deprive his inland lot of the right to have access to Buzzards Bay over the land that he drew on that plan, over the way that he drew on that plan. So by implication, and implication, of course, may arise even with regard to registered land, right?
Implication may.
Right.
Well,
So that would have imposed easement rights upon the severance of the lot from common ownership. And the derelict fee statute, the ownership of the fee is immaterial to the right of access over the way.
Your Honor, easement by implication was not litigated below, and what the owner intended when this last part of the development, this kind of tack-on piece to the development was being created, when he owned the property and when he deeded away this, already having Southern Shoreways, already having one that gave access to a community beach less than a quarter mile from where we were, there are a number of factors that could go into that question. It was not raised on the summary judgment motion, and by operation of law, if the derelict fee statute applies to this instrument, then the intent of the grantor does not come into play unless
As
the
to
instrument...
the boundaries of the fee, but not as to the, I mean, I don't know if you're familiar, your colleague on the other side cited the case of Adams versus the Planning Board of Westwood that involved similar circumstances, where the circumstances of the conveyance out of the two front lots passed the fee in each case to the center line, depriving the backland of access. And we held in that case that an easement by implication necessarily arose and that could serve the subdivision of the backland.
Having been a couple of days since I read that in other cases, here I don't recall whether that issue was litigated or whether it was decided as a matter of law that the implication was...
It was litigated. It was litigated.
Whether it was a disputed issue of fact or whether it was decided as a matter of law, the intent of the grantor.
Look, I'm not trying to sort of raise a new theory that wasn't engaged in the court. But I will confess to a little bit of puzzlement at the relatively facile comment by the motion judge that black and white, if the derelict fee statute applies, then there was no possibility of an easement.
Can I ask along those lines, do you agree that on the day the Anthony deed was conveyed, the 7th shoreway was shown on plans in registration case 11518?
Yes.
You do. Okay, so the Anthony deed says there is appurtenant to the described premises, which is to say your client's premises, a right-of-way in common with others entitled thereto, in and over the provided way is shown on plans in registration case number 11518. Why isn't that an explicit grant of an easement over the 7th shoreway?
It's a grant over all the ways, but
Including the 7th shoreway?
Unless the 7th shoreway is part of the title that was being given that day pursuant to
Well,
statute.
okay, so the derelict fee statute, since obviously someone could give an easement and not the whole fee, we now have a deed that actually describes what your rights are in that way. The derelict fee statute says it doesn't apply when, and I quote, the instrument evidences a different intent by an express exception or reservation, and not alone by bounding by a sideline. We have a deed here that doesn't have mere bounding by a sideline. And I guess I don't understand why saying I'm not giving you the fee, I'm giving you an easement, isn't an express exception to giving you the fee.
Your Honor, it was not an express statement concerning the 7th shoreway.
It is, of course, an express statement concerning the 7th shoreway. You just told me all the ways. And the 7th shoreway is one of them, for sure, right?
Your Honor, I do not think it was, I would disagree that it expressly referenced the 7th shore, an easement in the 7th shoreway by name. And
you think it covered, what's the street that you're on there's another way bounding it, right?
Westwood Road is the street.
Westwood Road. Do you say you own the fee in that?
Your Honor, I think that as a matter of construction under the derelict fee statute, yes, my clients would own a
So you
fee.
can now put a lawn on half of Westwood Road there. Is that right?
If nobody else had the rights in it and nobody else complained, in theory, we could, yes. Your
If
Honor.
nobody.
Well, that's the point. People have easement rights. They have easement rights, and those easement rights were created by the reference to the plan and saying that everyone has rights to pass across the ways shown on the plan,
I mean, your case seems to prove too much. If you own Westwood Road up to the median line, this is a pretty crummy development.
Okay, Judge Massing has a couple of questions. We are over time.
Let's assume there is an easement. You're not, this is towards the latter part of your brief, where your clients have built a driveway in front of it. You wouldn't contest, you're not contesting the easement holders, if there is an easement, right to sit, recline, remain, and get access to Buzzards Bay. The only thing you're contesting is the ability to drive a car down it.
No, Your Honor, we're contesting, we maintain that if there is an easement, the only right is pedestrian access, carrying what you would normally carry down to the beach over that way. It is not effectively a public park. That's simply saying in and over, which we've cited a few cases where we're able to find that language, seems to be a colloquialism for easement granting, at least in some situations. Only gives, it's still a right-of-way in and over. A right-of-way is the right to pass and repass, the right for ingress and egress, not the right to sit and have a picnic, watch the boats, et cetera.
Okay. Do you argue that in your brief, or, I mean?
Yes, we do argue that in our brief, Your Honor.
Thanks.
Okay. Hearing nothing further, thank you very much.
For the defendants.
Chief Justice Green, Justice Rubin, Justice Massing, thank you for allowing me to be before you. My name is David Udy. I represent the defendants, plaintiffs, and counterclaim in this case. I just want to say kind of off the bat that this is not a classic derelict fee statute case where an absent-minded developer forgets to deed the fee in the way and we need to clean that up. This is a carefully planned development with inland lots, waterfront lots, ways that go through them, carefully spaced shoreways that are 40 feet wide, equidistant from one another, 2 registered parcels from one another. The clear intent here was to create a community and to maximize the value of inland lots, to give them access and to give them a space to view the ocean. That was the intent here. And so what has happened here is a waterfront lot owner who already has maximum exposure to the water decided to commandeer the 40-foot wide 7 shoreway and build a glorified elevated side yard by adding hundreds of cubic yards of fill, putting in an irrigation system, putting in hardscaping, landscaping.
Which, if their legal theory is correct, they were perfectly entitled to do.
And the reason why I think their legal theory is incorrect and is the case of Hickey, which is a Supreme Judicial Court case from 2015. And that case was virtually identical to the case that...
Except that none of the deeds it construed were actually issued after the 1971 adoption of the derelict fee statute. I know it says deeds after, or what does it say, property, registered property, but the question is conveyances, right? And the statute seems to say that even conveyances of registered land after the effective date are subject to the statute. Now, if the SJC had already ruled on a conveyance after the date and found otherwise, of course we'd be bound by that. But I looked at that case. It doesn't look to me like they actually, that the operative deeds are the ones from after.
Well, that's a great question, Justice Rubin, and this was brought up before the land court judge below. And one of the arguments that we made that is expressly in the land court Judge Vay's opinion is that if you look at and read Hickey, there are deeds out from the developer both before and after the enactment of the derelict fee statute. And what the SJC says in its case, and it didn't need to say this, and in fact it didn't just say it once, the SJC said it twice. The SJC says on page 752 of its opinion, quote, "The derelict fee statute does not apply to land registered prior to its enactment and thus is not applicable to any of the lots at issue here." That would include the ones that were deeded out after the advent.
They were deeded out by the developer. They're not subsequent deeds from someone who took from the developer.
Correct. There's a footnote in Hickey that talks about that. It talks about that there were deeds out going all the way into 1977, and that's also cited in Judge Vay's opinion. The SJC said it again in footnote 13 of Hickey. It says, quote, "Common law principles apply here because the derelict fee statute enacted in 1971 and amended in 1990 does not apply retroactively to registered land, period." It didn't have to say that. It could say doesn't apply to instruments executed on registered land prior to the advent of the statute.
That's what the statute says.
That's one reading of the statute, but the statute, if you look at the Mass Acts, it talks about instruments conveying title to land in the first part when it cites the derelict fee statute, but the second part just talks about instruments. And I would suggest here that one of the instruments at issue is the actual recording of the registration plan in 1967. That instrument created the 7th Shoreway and it created the lots. And so if you look at Hickey, and I'll find that site for you, Justice Rubin, I have it here. It talks about that the land was conveyed out after in the 70s. We cite it in our brief. It's expressed in our brief. I don't want to delay time on this, but it's in our brief, and it's in the land court justice's opinion that lots were deeded out both before and after the advent of the statute. So this court, with great respect to this court, the land court found that it was bound by that language in Hickory. The SJC didn't have to say all land registered prior doesn't apply, but it did. And it didn't just say it once, it said it twice. So with great respect to this court, I would submit that this court is also bound by that holding in Hickey. And my brother doesn't cite to any cases in his papers that would provide any contrary guidance on this issue. And this is a recent case from the court.
You just mentioned something about a 1967 instrument deed. What were you referring to?
So the plan that created the lots, I'll call it the Conway lot and the Caragliano lot and the 7th Shoreway and the extension of Westwood Road, that plan, this is the 13 plan.
Okay, 61, right?
It's dated at the top in 1961, and then if you note, it was presented to the land court for registration in 1967.
Okay, thank you.
And that predates the advent of the derelict fee statute. So that could be an instrument that created the 7th Shoreway, and that would preclude the application of the derelict fee statute. And the SJC said that in its opinion. It applies to all land registered prior. And there's not a case that adjudicates this issue to the contrary. So that is the first issue in this case. And so if the court finds that the derelict fee statute does not apply, including for the reasons that Justice Rubin, you articulated, and Justice Green, that you articulated in questioning my brother, there are other grounds that the court could find that as well. If you go to issue 2, whether or not the common law standard that applies to this, I don't even think it's a close call. I can go into the facts that the court would like, but if you look at the facts of Hickey, they virtually are identical to the facts of our case with respect to whether the developer, here in our case, Boardman, intended to grant the fee in the way. And the clear intent here was that Boardman did not. And again, it mirrors Hickey, for the very reasons that we talked about. It's a Cape Cod development of registered land. You have inland lots, you have waterfront lots, you have these 40-foot wide shoreways. The clear intent was to let the inland lot owners use these shoreways based upon the terms. Was
that intent even clear enough to overcome the derelict fee statute?
I'm sorry?
That intent even clear enough that it would qualify under to
Absolutely, absolutely, Justice Massing. I mean, it's very clear that what this is. The waterfront lot owners do not need an extra 40 feet of common space to build a glorified side yard. That was not the intent of the grantor here when this community was set up in Cape Cod. The intent was to maximize the profitability and the value of the inland lots. And Justice Vey found that.
Do you think that the landowners who took lots from Boardman prior to 1961 that had this language about all rights in common to all ways shown in case 11518, do you think that when new ways are registered in case 11518, that their deeds now include that as well, or no?
Absolutely. Yes.
Do you have any case law or rule that tells us that an after-created way can be included in that way through a registration in a case?
Sure, the Hickey case. The Hickey case is the Hickey case, the SJC Hickey case from 2015. It is virtually identical. It's the same. You had one large parcel that over many decades was subdivided. New subdivision plans were presented to the land court for registration, and all the certificates of title had similar language to what the Caraglianos have in this case. There is a pertinent here to the right of in and over all the ways shown on the plans in this registration case number, and that's exactly what happened in Hickey. So as new ways were created, as new parts of the subdivision are created by the recording of successive plans, those parties have access to all of the ways, including the way at issue in Hickey.
Do they have to get a new certificate of title?
No, Your Honor. The certificate of title, by virtue of the fact that it references the very plan in which all these subdivision plans are presented for registration, is sufficient.
Let's talk a little bit about the in and over language.
I'd be happy to, Your Honor. So, if I can just fast forward here. So that's issue 3. The Caragliano certificate of title has the following language. There is a pertinent to their property, a right-of-way in common with others entitled thereto in and over the ways shown on the plans in case number 11518.
In your brief, you cross a bridge in talking about that language, saying that they have the right not simply in and over the easement, but to be in the easement. It seems to me those are two different things, because we're talking about an abstract interest of title in the way.
Right.
And a physical right to be in the way in a stationary position is, it seems to me, different in many respects, and those respects seem to be the source of the controversy here.
I agree that there's a controversy. I don't agree that there should be, Your Honor. I think when you have...
Well, there won't be at some point, right?
Agreed. If you have the words, the right to go over a way, that presupposes you have to be in it to be able to go over it.
Well, no, in and over
it's not a question of to be. The question is the nature, the existence and holding of the right. So we have a right in the easement. The words to be in the easement are not part of it. That is a part of whatever the rights are. The rights of the interest holder are those rights.
Depends what is means, right?
No.
But the judge did find that he was allowed to look not only at the subsequent uses of the easement, which of course are a tricky thing to use to figure out what something previously intended, but also at the circumstances surrounding this, and concluded these are not mere walkways like we might all be familiar with going to a beach. These are 40-foot wide grassy areas. Some of them have been maintained in that condition for whatever, 50 or 100, I don't know how many years. And that the intent was, that his intent in using this phrase, I don't think we should say that it's all, in and over is used an awful lot for easements, and I don't know that, I've never seen a case where this question has even been presented, but he says they were open park-like areas to give some benefit to the inland people, and the way they're laid out suggests not just for walking to and from like a path, but a park-like area where, consistent with not infringing on the rights of others, you could put a picnic blanket down or watch a sunset.
And that's in fact what the factual, undisputed factual record shows, that people have used, including the Caraglianos, used these park-like 40-foot wide shoreways for. And I would say too that the land court justice did a view in this case, and that informed his decision about.
But generally speaking, the holder of a right of way to pass and repass that includes vehicular access also includes the right to make improvements as necessary to enjoy those rights, so that the current state in an unimproved natural condition is not an essential feature of the easement itself, easement area itself.
Well, I would say
someone could bring asphalt and pave it all the way down to the shoreline, right?
Well, I think the standard is to look at the intent of the grantor here by setting it up the way he did. And he set up 7 grassy, 40-foot wide shoreways, not narrow paths to access the beach. So I think one of the reasons...
But that implies, I mean, this was among the other ways throughout the subdivision that provided access to each of the lots. Those were paved.
Correct. Those were roads that allowed people to reach their driveways versus...
But there's nothing from the language of the deed or the nature of the plan that, I mean, these happen not to have been paved as part of the original development, but there's nothing inherent in the nature of the ways that requires that.
Requires what, Your Honor?
That the shoreways remain in a natural state.
I would agree. There's nothing that requires that they be in a natural state. I think that
and if you were to suppose or imagine that the way was paved just like all of the other roads.
By whom?
By the holders of the right to use them for vehicular access.
You'd have to get everybody to agree?
How you get there is a different question, right? I mean, it's the nature of the right. That does not imply the right to sit on a blanket, right?
I think what's implied, the right to be in, is number one, the language of the grant. That word did not need to be there.
The right is in the way, not the right to be in the way.
I respectfully disagree with that interpretation.
Yeah, how can the language get you there if it's the same language for Webster Road?
I'm sorry, Your Honor?
The same language applies to Webster Road as applies to the 7 Shoreway.
Right.
I mean, so you can't rely on the in and over, because that would, as they say, that would allow you to picnic in the middle of Webster Road.
Yeah, and so that's why I think not only do you look at the language of the grant, you look at the actual plan and the intent of the grantor, what these things were set up to do.
You have to.
Westwood Road was set up so people could drive to and from the development, get to work, and go to their house. The shoreways, the 40-foot wide, initially grassy shoreways, were set up so people could be in and enjoy and view the water and also access the beach.
So you have to appeal to something beyond the language of the easement to get you there. You have to.
Yes.
Westwood Road was 40 feet wide too.
Understood, Your Honor, but I think the implication when you look at the plan, which one has to do in assessing the intent of the grantor, is to say the roadways, called Westwood Road, is for people to access their homes and access the greater world, whereas the 40-foot wide shoreway that's initially grassed over leading to the embankment, leading to the beach, that's for purposes for inland lot owners to have recreation space, common space in this development.
Can I ask this? I know your time has expired. Under the court's order, do you understand the Conways to be allowed to put the bocce court back?
Yes, that is not an issue.
Why? Why is that not an issue?
Because that is how what the relief that we sought was to restore the 7th Shoreway how it was before the Conways purchased it.
And do you think that they have a right? I mean, I understand under the order they do, but what right do they have to put a permanent bocce court over the easement?
None, and that's not something the Conways put there, but there are other means to petition to get that removed after this case is concluded. We want the bell to be unrung of what the Conways did, no more, no less.
So the lesson of the case is, don't have neighbors.
Just one more question for you. We skipped it. We got away from this before I could get the question in. Under your theory of the case, who owns the fee in the 7th Shoreway right now?
I think the fee is still owned by the grantor, by Boardman.
Boardman, okay.
Yeah. Thank you, Your Honors.
Thank you. Thank you, Paul.
It's a really interesting case, guys. It's fascinating.
Well, you know, to have a good easement case, but have it involve registered land to boot, I mean, it's...
It's like
oh, joy.
It's a party up here. It's unbelievable.
Thank you.
That brings us to the final case on our hearing list this morning, case number 2022 P92, John Doe number 375532 versus the Sex Offender Registry Board. Welcome back, attorneys Janai and Tomasco.
Good morning, Your Honors. May it please the Court, Alexi Tomasco, in a limited appearance for Mr. Doe. I'm going to focus my time on arguments 4 and 5. That's the question of the review of the expert testimony here and the question of recusal or whatever happened in terms of the evidence being passed around. I want to just start to inform the Court that from what I've been told, or what's been represented to me by board attorneys, both on the record and privately, this is a fairly unique hearing where the attorneys themselves do not prepare the evidence. Someone else, for all the exhibits, it is someone else at the board, and then they mail things out. And I say that that's because that's important.
Wait, I'm sorry, I don't have any idea what you're talking about.
Yes, that's why I wanted to start with that. There is some group at the board that prepares exhibits.
Well, there's some group at the U.S. Attorney's Office probably that prepares exhibits, but they work for the prosecutors.
Yes, the board attorneys have nothing to do with that process.
Do the hearing examiners?
The hearing examiners do not. According to Chief Hearing Examiner Tracy Downs, she does not have any part. They only receive some packet. Everyone receives some packet.
Everyone, including opposing counsel?
Yes.
Okay.
There's something that's sent out. The presumption is that they're the same thing that gets sent out.
Sure.
But we don't have a situation in typical litigation where you have the attorney there and certainly as an officer of the court. The identity is often unclear who does this, and I don't believe it's an attorney to the best of my knowledge. Certainly putting that aside in this case, the attorney very clearly on 2 different occasions puts forward that he had nothing to do with this evidence. One saying, if there's any mistake in the ordering, that's not my mistake, and then later saying, I haven't touched this case at all. So there's the general practice, but certainly in this case,
Did you ask for an evidentiary hearing on the recusal motion?
I did not.
To find out what the lawyer for the other side would say happened, even?
So, right, there was no responsive filing by the board, and I was going to observe that there's certainly something that, given this construct where the board attorneys aren't involved in the assembly of the record or the exhibits, at no point before this court or before the MJOP is there any averment by the board attorney that says, I went and looked at everything and it's all the same. And I think that's something that's important because, again, that's how regular litigation works, right? I mean, the attorney says, these are the exhibits and I've prepared them, I know what's in them.
I mean, we do have some weird cases where the judge tells us something, like when they're reconstructing the record or something. I find it very odd. The hearing examiner's opinion isn't under oath. The hearing examiner isn't subject to cross-examination. You know, of course, we all take sort of what the judge says as true. We sort of do that with counsels of affidavit and ineffective assistance cases, and it strikes me as wrong, but I'm not sure that's a battle.
So, but I'm sorry, I don't get it. I mean,
yes.
So there's 5, according to the hearing examiner, there's 5 exhibits. They're exhibits. And, isn't it like at a trial, like the judge, the clerk's got 5 exhibits. Your Honor, can I see those 5 exhibits? Can I show them to the witness? I mean, what's the problem?
Right. So there's 2 problems here. And again, this is part of the source here, right? And in any kind of litigation, I have had cases where you submit copies of the exhibits prior to submission to the court. It allows the court to follow the evidence without having to grab the exhibits as they're offered. We don't have that examination here. And from the affidavit of counsel, and from what we understand by the ruling, that did not happen. That brief moment that we see in all other trials where the attorney walks up and says, do you want to see this exhibit? And many times we say, no, that's fine, I've seen it before. That does not appear to have happened here. There's a visual where he says, well, we have all the same things, but as counsel points out in affidavit, the board attorney starts reading something that's not in any of those exhibits. Now, it may be that the hearing examiner had printed out the Superior Court decision. It seems that that's heavily referenced later on in the cross-examination of the expert. But it's certainly the board attorney who came in with nothing is reading something that's not in the exhibits that are listed. This is something that we could have.
What should have happened in your view? So we don't know because there's no evidentiary hearing.
Yes.
The lawyer walks in with nothing. Should the case be dismissed? Should the person be designated a level 1? Should it be continued? What's supposed to happen?
So, yeah, that's an excellent question, right? I mean, I think in the standard litigation where we have...
Well, I've never seen someone come in with nothing, so I don't know.
I mean, I think it's certainly, yes, there's a good question of what happens if someone comes in without exhibits. And certainly, I think a judge or a hearing examiner could be like, you don't have exhibits, we're done, right? It's your job to produce this evidence. Asking for additional time would be a reasonable thing. I think even under this case, the moment of, here's what we have, can you just double check that these are the same, right? That would have been a pretty good solution. I think after the fact, whether it's, I'm not sure it would be technically reconstructing the record, but I have nothing but admiration for all the board attorneys. If one of the board attorneys said, I went back and looked at all these exhibits and they're the same, right? That has not happened here. We simply have no knowledge of what exactly came out. We have this hope that it's the same, but we have some evidence on the record that there are documents that are being reviewed.
Sorb did not oppose your motion for recusal?
No.
Really?
No filings by the board attorney after the post-hearing motion. No affidavits either. And again, no affidavit before the
No
Superior
opposition.
Court.
The hearing examiner denied the motion. Interesting.
I don't know that that's inherently...
I mean, that must happen, of course, all the time. Someone files a motion for whatever, something they're not entitled to, and it's denied. No one, but you see that all the time, sure.
The board attorney in this case, who I've been across many times, in my experience, has filed one opposition. He's no longer with the board, but For all of the motions I've ever filed, I think there was one opposition. And again, he is incredibly experienced, and I'm not going to criticize his way of litigating cases, but it is not at all surprising to me that there was no opposition in this case. It would have been quite to the contrary. I would have been very surprised. Of course, Attorney Sinai may have information that I'm not aware of, but to my knowledge, there was no opposition here. So then, turning to the recusal, after we're dealing with this kind of mess about whatever happens, right? They go off the record. We only have this affidavit after the fact. There's this question about how do we handle the hearing examiner in this case? And this is why I want to focus on the two issues, both in terms of the evaluation of the expert, which I think to some degree overlaps with where we are here. We have the original hearing, 380-316 comes out, there's no decision. We have our second hearing, and that goes up to, there's a decision, a level 3, that goes up to Superior Court. Superior Court remands for expert funds, which I think is critical here, and then evaluation of age and mental health. In the hearing at record volume 555, the board attorney specifically invites the hearing examiner to disregard that opinion. The board attorney says, meaning no disrespect to the Superior Court judge, they're young and they don't understand the factors, and you should plan accordingly. And that's reflected in the decision in multiple places. In many ways, somewhat oddly, in terms of evaluating age, the hearing examiner goes out of their way to say, they got it wrong, and I'm not going to follow the Superior Court decision, but the times have changed, and now there's a 5-year gap. So it didn't apply before, I didn't credit it, but I'll credit it now, which is a fairly confrontational issue, right? They could have just said, 5 years applies now, and I'm going to credit that. They go out of their way to say, I am not following the Superior Court rule, but now anyway, times have changed. The hearing examiner does that again later on. And that's invited. That's just the board attorney.
And that has bearing, I take it, on the question of what is the danger rather than risk of reoffense. Maybe something on risk of reoffense, but also the danger, since the only contact offenses occur when he's 13 and the girl is 14, and when he's 15 and the girl is 15.
That's certainly correct, Your Honor.
And is that what the judge wanted them to look into?
So I think my understanding is that one of the things that the judge, and I think wanted is not the right word, instructed the hearing examiner to look at, was a calculus of offense-free time, calculating both the time between the contact offenses and the index offense, and then after release from the index offense to the time of the hearing. And I'm sympathetic to the hearing examiner saying, well, I'm bound by the regulation, but the hearing examiner is also bound by a Superior Court order. It's not appealed.
The time between the offenses is different from the question that Judge Rubin is asking.
I'm sorry.
I'm asking about
the difference between contact and non-contact offenses as they bear on dangerousness.
That is, the dangerousness has to do, to some degree, with what the likely conduct will be of this person if they reoffend. And what I'm saying is, do we know anything about when a 13-year-old touches a 14-year-old? Does that tell us anything about their likelihood as a 30-year-old to touch either, and this is really what the hearing examiner seems concerned about, a 14-year-old, or about their likelihood of touching anybody?
So,
and I didn't see anything in the hearing examiner's opinion that explained that, except this refusal to look at age.
So the regulations themselves distinguish between offenses committed between juveniles of similar ages versus an adult committing an offense against a juvenile.
And is there anything in either the regulations or and I'll ask Attorney Sinai about this as well, about the likelihood of a viewer of child pornography having a contact offense with a child?
There is a substantial distinction. Online, use of online unlawful pornography is very different in terms of recidivism for contact offenses.
And that's in the regulations?
That was added in the amended regulations, and it's in the late 30s in terms of how to evaluate online.
Wait, when was it added?
He's talking about age.
Oh, I see. No, I'm at,
The regulations have changed in terms of how they instruct hearing examiners to assess online offending versus.
And did the hearing examiner apply those?
Not to my knowledge. I think this
it
is a
looks
case.
to me like, and you point some of this out in your brief, her real concern, it's everyone's real concern, is this someone who, with whatever he said, a conclusion that minors may be sexually appealing is something he said once, and of course he downloaded a lot of child porn. Is he a risk to watch more child porn, or is he a risk to touch a child? Touch a child is obviously, well, actually, I think there might be a holding actually from the SJC that non-contact offenses, I think they say, are not even moderately dangerous. I don't know what we think of child pornography, but she says high degree of danger, and I'm just trying to figure out if there is a link anywhere between watching child pornography, downloading and watching it, which is horrendous for all the reasons it's horrendous, but does it predict in any way a likelihood of physical contact?
I do not believe, under the circumstances presented here, that there's any studies, and I'm sure Attorney Shanai will know this, that that's predictive. The decision as written, and I'll wrap up very quickly.
It's okay with me if you keep going, but I'm not the presiding.
Just to finish answering the question, I appreciate, and a two-part answer, but the decision as written bootstraps the earlier offenses in order to give a suggestion of contact offenses to the index offense, which is not contact, and also does a second thing, which is important to both of these, that they take this VOP, which again is reinforced by the board in all its motions, and suggest that there's contact with under 18 individuals. And again, that's the current threat, is that this continues.
We don't know even why that.
No,
Oh, I'm sorry.
Oh, you want to ask one more question?
May I?
Yes, you may.
Thank you. We don't know from the record whether, we know that was alleged, unsupervised, I don't know if it says contact, with, but it doesn't say sexual contact, just unsupervised contact in Needham and Newton twice with someone under 18, but we don't know if that's, we don't have the violation finding?
We do know, we don't have the violation finding on record 124, and I'm sorry, I didn't write down which volume, I think it's 124, there's a letter from the board to probation where probation handwrites on the bottom, violation only for new charges. So we do know it would be great if we had a transcript or the findings, but there is an affirmative evidence in this record where probation writes back and says the violation was solely based on the new charges. But other than that, I rest on the brief. Thank you very much, Your Honor.
Thank you. Mr. Chennai.
Thank you. If it pleases the court, David Chennai for the board. Driving in, I was thinking, doing these cases, I sometimes feel like Bill Murray on Groundhog's Day.
Well, here we are.
Here we are again, and and one of the reasons is this individual has been eligible for reclassification since March of 2022. So no matter what we decide here today, he'll be in the reclassification process because the second decision in 2020 was actually a non-hearing. It was just a remanded decision to put in explicit findings regarding internet dissemination. The actual hearing, where there was a decision on a hearing, was in 2019. So that's really the status of the case. You know, I think my brother counsel is correct. The system the board uses is when it develops the files for a case, I don't actually work on getting all the evidence together. The evidence is sent to me in a package of documents. And the same documents are sent at the same time to defense counsel, and the documents are also sent to the hearing examiner. So all three have at the hearing the same documents. And the process is, because now with the computer especially, I generally go through the documents. Defense counsel looks through the documents, makes sure that we have the same documents, and then the hearing examiner also checks and makes sure that they have the same documents in the same order. And that's essentially, the board says that I'd be submitting these documents, which the hearing examiner already has. And that's kind of how the proceedings have been going. And in this case is a good example. The hearing examiner had the exhibits, defense counsel had the exhibits. The exhibits obviously didn't get to the SORB attorney on time for the hearing. So basically the same exhibits the SORB attorney would have had, the hearing examiner had, and gave them to the defense attorney.
But we don't know why the person didn't have the documents, right?
My guess is it wasn't mailed to him on time, and I've had this issue in the past. In fact, just last week, 2 weeks ago, I had a hearing where I didn't receive the documents, and I had them all emailed to me so that I would have them, at least on my computer, while I did the computer-generated or WebEx hearing. And again, these things can happen, but the reality is that defense counsel at the time and the hearing examiner had the same exact documents, and the hearing examiner pointed out that it wasn't objected to by counsel at the time, that they were admitted into evidence as such.
So these documents are mailed?
They're mailed to me because I'm obviously in Williamstown, Massachusetts.
I understand, but they have, I know that there's been some issues with broadband in the western part of the state, but you have the internet.
Yeah.
I mean, you know.
You could print them out.
Have a, well, if he doesn't have access to I mean, you would imagine that there would be, these things are all digitized, right?
Well, Your Honor, I got to tell you,
they were emailed to you.
The state won't give me my own printer. They won't give me ink. So when I get 300 pages, I'm not printing it out.
The question whether you can work from a tablet or work from a hard copy is one that we have on a regular basis internally here, but we've sort of bitten the bullet and gone to the screen. My point is that you know, you say you had them emailed to you. It's fascinating to me that they are not simply readily available from a central repository to which all parties, the defense and the hearing examiner and board counsel, would have access to download them.
I don't think the board's gotten that far ahead in technology.
I regularly send you back with encouragement, Mr. Chennai.
I will encourage, as always.
Add this to that list. It seems to me that this...
it should go right under telling us the percentage likelihood of recidivism. That would actually really help.
We've had a number of different conversations on the regs
Yes.
and other things, but the, you know, the idea that in, you know, I'm not trying to bring you into the 21st century, just the 20th.
Well, on a good note, I do want to say that I think the board is close to its final version of the new regulations, which will probably be going, they're hoping, by end of May to have the public hearings on. So we're making some progress in some areas, Your Honor.
Can I ask you about the risk of danger here?
I was just going to go back there.
Okay. 496501 says, and I quote, "An individual is generally unlikely to pose a moderate degree of dangerousness where his or her risk of reoffense relates only to non-contact offenses that do not put a victim in fear of bodily harm by reason of a contact sex offense." Now, the hearing examiner here both refused to look at the age question that she was ordered by the Superior Court to look at, I don't like that. And clearly was concerned about, as I said to your brother, the thing that concerns us most. What do you mean he's babysitting a 4-year-old? What do you mean he's got access to children at his own children's birthday parties? But she doesn't explain anywhere that I saw, maybe you can explain to me, or maybe it's in the regs, that looking at child pornography creates a risk of a contact offense. Obviously it may, I don't know anything about this, but she doesn't sort of connect that dot.
Well, first of all, that really applies to, I mean, if you look at factor 36, it applies online viewing, applies when that's their only sex offending behavior. And the board clearly says that if it's just viewing child pornography on a computer, no other sexual behavior, that in itself doesn't necessarily have an increased risk or danger. But DOE 496501 also says when you're looking at dangerousness, you also have to look at an individual's prior sexual behaviors to determine whether or not they pose a danger.
And why, though, do we think, or did the hearing examiner think, I don't know what we think, I don't know if it matters what we think, why did the hearing examiner think this person is likely to reoffend by touching a prepubescent child? That's the risk she described repeatedly. Why does she think that's the risk here? I'm not saying it isn't, right? His index offense is pretty bad, but go ahead.
The issue is that he actually has at least one we know of specifically a touching contact sex offense years ago.
With a child?
Correct.
Here.
Right.
But he was younger than she was.
I understand that, but he also had bizarre sexualized behaviors.
I agree with that, but I'm asking about, right, the other offenses might come into the lewd and lascivious kind of things, but not contact offenses. Yes, he grabbed the buttock of a classmate when he was 15, and there's this act when he's 13 that's terrible. But he was 13 and 15. I'm asking, what's the evidence that he's a risk to have a contact offense, let's start with a prepubescent child?
Well, I was kind of connecting the dots from the contact sex offending right through the sexualized behavior, but his records, all of his records of while he was in treatment, or at least being evaluated, he didn't really do a lot of treatment in sex offender treatment, but while he was being evaluated, there were red flags of his sexualized thinking, his sexualized behavior, his statements regarding prepubescent children, his interest in prepubescent children, and then his collecting child pornography.
Okay, but let me ask it a different way. If someone came in and they had collected child pornography, could a hearing examiner find that they are a risk, high degree of danger, because they may touch a child? And if so, why is that?
Well, the simple answer is that his own expert found he was a moderate risk to reoffend.
I didn't say he wasn't a moderate risk.
I know
I'm
that.
asking about high risk, and I'm not talking about reoffense. I know your brother talks about this. Obviously, one of the problems with the whole process is the kind of impressionistic quality of moderate or high. But there were reasons for rejecting the moderate and going with high. And he's reoffended maybe a lot, certainly some, okay. But the danger is the part that I'm not sure about. Now, I'm not saying he's not a high degree of danger, but I just didn't see, you say contact offense. If a 13-year-old touches a 14-year-old, that's a lot different than a 30-year-old touching a 14-year-old. They're completely different. Who's a 13-year-old? Not that they should touch without consent to anyone.
Well, not to mention that the 14-year-old is not prepubescent.
Well, she's not
Right.
prepubescent, that's true, of course, also.
Correct. But again, the incident that we're referring to was more than just a contact sex offense. It was he forcibly digitally penetrated and also put an object into the girl's vagina.
Yes.
Which again goes to the odd sexualized behaviors he's exhibited over the years. And because he has...
So is your position that there's some factor about varied sexual misconduct or something?
Now, my position is that when you take the whole picture of this individual, it's clear that the hearing examiner found his behaviors through the years and the things he revealed in treatment to be very concerning as to both his risk and his danger to commit another contact sex offense. And more importantly, he had gone from...
And do we know that there is a predictive value of what a 13-year-old does with someone his own age to continuing to commit contact offenses when they haven't had one in 15 years? Is there data on that?
I'm not sure about the data on that. I'm sure that what the board's position is that if this individual had, and I think your argument would be stronger if the individual committed the act at the age of 13 and then later, 12 years later, has child pornography. He's got a whole history in between that the hearing examiner is evaluating.
But we have to look for clear and convincing evidence.
Correct. And the hearing examiner
And
found
I'm not even, you're not really telling me that there's a clear link between observing child pornography and contact offenses.
I'm not saying that, but I'm saying in this individual's situation with prior contact sex offending behaviors and his history and his seeming to moving from teenage girls and adult women to now children, prepubescent children, is concerning. And again...
Well, obviously it's concerning.
Right, but this isn't an individual who... that his life is in a vacuum. This is an individual who seems to be progressing in a direction, and he does have a history of contact sex offending. And again, that's the strongest argument the board has for supporting the hearing examiner's decision. There is an elevated risk from this individual by the hearing examiner's by the individual's own expert, who said at the minimum he's a moderate. And again, the expert...
She only mentions danger, I think, once.
Yeah, she was doing a risk analysis.
She was really talking about reoffense.
But we don't... But my sense is that if you look at it, I don't think she's saying reoffense for child pornography, because she thought the index sex offense was a lewd and lascivious.
But then all she's talking about is lewd and lascivious. But look, there are... okay. That's not a contact offense either.
This is true. But again, I'm not sure that if you have a moderate risk with this individual's background and his history... And
I'm not sure that you do, but there has to be clear and convincing evidence that you don't.
This is true. Again, the board's position is that the hearing examiner properly found by clear and convincing evidence that...
What do you do with her refusal to follow the Superior Court's instruction to look at age? She's allowed to look at anything under that catch-all factor at the end, right?
Correct. But I don't think she found that the age issue that the judge raised, she felt that the board's regulations dealt with that appropriately and didn't feel that she needed to add any more to that. There wasn't like... there were massive amounts of studies submitted regarding the individual's age and reoffense. And the other thing is he committed a new sex offense as an adult, which again the board's regulations handle. And as for the time between offenses, again, factor, she makes it clear, factor 29 doesn't refer to that period of time. And more importantly, Dr. Guidry said that period of time would be irrelevant in an analysis anyways. So unless, I know I'm over time. So
see that your time has come to an end, and with it, the conclusion of this hearing and our session.
Thank you, Your Honor.
We are adjourned. Thank you both.
Thank you.